I'm reading out of the Reference Guide to Regulatory Compliance, reading the out of page 934 of the old text, the Right to Financial Privacy Act. The Right to Financial Privacy Act was passed in 1978. The purpose of this law is to protect the financial records of individuals from unwarranted access by the federal government. The Act establishes criteria under which federal government agencies may obtain financial records. The Act imposes a duty on financial institutions to screen requests for information to ensure that they meet the requirements of the law before requested records are released. Subsection 1, coverage. A, federal agencies or departments. 1, applies only to requests made by U.S. government agencies. 2, does not apply to private party requests for those from state or local government representatives. B, customers. Federal agencies or customers. Any person or authorized representative that a person who used any service of a financial institution or for whom a financial institution is acting or has acted as a fiduciary in relation to an account maintained in the person's name and covers individuals and partnerships of 5 or fewer individuals. Financial record. Any record held by a financial institution pertaining to a customer's relationship with the institution. Subpart 2, requirements. Release of financial records to any agency of the United States government. No release may be made except through one of the permissible methods listed here. Authorization by customer must have a signed and dated authorization from the customer, state the purpose of the disclosure, not authorize disclosure for a period longer than 3 months, identify the records to be disclosed, state the customer's rights under the Right to Financial Privacy Act, state that the customer may revoke such authorization at any time before the financial records are disclosed, and G, state that the financial institution may not require an authorization as a condition of doing business. For an administrative subpoena or summons, may accept only if there is reasonable belief that the records are relevant to the legitimate law enforcement inquiry, and a copy of the subpoena or summons along with the prescribed notice must have been served to the customer or mailed to the last known address. And C, must wait 10 days from the time of service or 14 from the time of mailing notice to the customer before releasing records, and cannot release records if customer has filed a motion to squash the subpoena. To quash. 3, search warrant. Government must mail a copy of a prescribed notice and the search warrant to the customer within 90 days after serving the search warrant unless there is a court-ordered delay. Judicial subpoena must be served by law and relevant to a legitimate law. Must be authorized by law and relevant to a legitimate law enforcement inquiry. The judicial subpoena, copy of the subpoena must be served on the customer or mailed to the last known address along with the notice required by the Act. 3, must wait 10 days from time of service or 14 days from time of mailing notice to customer before releasing records, and cannot release records if the customer has filed a motion to squash the subpoena. 5, formal written request. Only used if there is no available administrative summons or subpoena authority. B, request must be authorized by regulation. C, must be relevant to a legitimate law enforcement inquiry. D, copy of request along with the prescribed notice must be served on the customer or mailed to the last known address. E, must wait 10 days from service or 14 days from mailing to the notice to customer before disclosing information, and cannot disclose if customer has filed a sworn statement and application to enjoin the government authority in an appropriate court. F, institution not required to respond to a formal written request as it is required to respond to a subpoena. B, confidentiality of records and certificate of compliance. 1, the customer may not release the financial records until the government authority seeking such records certifies in writing to the financial institution that it has complied with the applicable provisions of the statute. 2, an institution must start to assemble requesting records on receipt of the government request and be prepared to deliver the records on receipt of the certification of compliance. 3. Good faith reliance on certificate of compliance relieves the bank from further liability under the Act. 4. If any officer, employee, or agent of the financial institution has information that may be relevant to a possible violation of a statute or regulation, he or she may disclose certain records such as the name or other identifying information concerning the individual, corporation, or account involved in and the nature of any suspected illegal activity. No certificate of compliance is required. And 5, a financial institution may provide copies of any financial record to any court or government authority when it is incident to perfecting a security interest, proving a claim in bankruptcy, or otherwise collecting on a debt owed either to the financial institution or in its role as fiduciary. Exemptions. Letter C. General records of information or information. Any records not identified with a particular customer. And regulatory examinations. Number 2. Agencies are entitled to examine any records in the exercise of their supervisory, regulatory, and monetary functions. Number 3. If the financial institution is being investigated and not the customer, the Act does not apply. Number 4. Grand jury subpoenas are not subject to the Act. A. On receipt of a grand jury subpoena, must determine if the crime investigated is against the bank or supervisory agency. If so, cannot reveal the existence of the subpoena to anyone. And B. Court order non-disclosure under certain circumstances. Court may order non-disclosure under certain circumstances. 5. Illegal activity. If the institution believes the violation has been committed by an employee, officer, director, controlling shareholder, or majority borrower, then disclosure may be made to a U.S. attorney or to a state law enforcement agency. 6. Financial records sought by a government authority under the Federal Rules of Civil and Criminal Procedure or comparable rules of other courts in connection with litigation to which the government and the customer are parties are not covered. 7. Information required to be reported under any federal law or regulation is not covered. This includes information required to be reported to FinCEN under BSA. Letter D. Internal Revenue Code procedures. The IRS may seek customer records in accordance with procedures of the IRS Code rather than rely on administrative summons. IRS procedures. The IRS must serve the bank with a summons and must serve the customer with a copy of the summons within 3 days after the bank was served. B. Notice to the customer must contain a statement of his or her rights, including the steps to take to resist the summons. 3. A customer who wishes to object must begin a civil suit to quash the summons not later than the 20th day after the day on which notice was given. D. No examination of the bank's records is permitted. Roman numeral 1. Before the close on the 23rd day after notice was given, unless the customer has consented. Roman numeral 2. Until a court so orders if a customer files suit. Letter E. Institution must begin collecting the records on receipt of the summons so as to be in a position to produce them on the specified date. F. Institution may be entitled to reimbursement for costs incurred in searching and processing the request. E. Access to information for intelligence purposes. 1. Information restrictions do not apply to government authorities authorized to conduct foreign counter or foreign positive intelligence that are gathering information for those purposes. B. Secret Service when it conducts activities under its protective function. And C. A government authority authorized to conduct investigation of intelligence or counterintelligence analysis related to international terrorism and or that gather information pursuant to those purposes. 2. Government authorities acting under this section may provide a certificate of compliance. Must provide a certificate of compliance. 3. No financial institution employee may disclose to any person that a government agency has sought or obtained information under this section. 4. Emergency access to records. Nothing in the law will prevent a government authority from obtaining access to information if the government authority determines that a delay in obtaining the information will result in physical injury to any person, serious property damage, or flight to avoid prosecution. B. In the case of potential physical injury property damage, or failure to avoid prosecution, the government will provide a certificate of compliance. C. Within 5 days of obtaining the information, the government authority must file a sworn statement in federal court setting forth the grounds for emergency access. Record retention. If financial institutions should retain copies of all evidence of compliance with the Act, including copy of subpoenas, written requests for information, and so forth. 2. Banks are required to keep a notation of each disclosure, including the date of such disclosure and government authority to which it was made, in connection with the authority's consideration or administration of assistance to the customer in the form of a government loan guarantee, or loan insurance program. The customer is entitled to inspect this information. G. Cost reimbursement. Except for records incident to perfection of a security interest, proving a claim in bankruptcy, collecting a debt, or processing an application with regard to a government loan guarantee, or so forth, or for certain exceptions, a government authority shall pay a fee for reimbursement for such costs as are reasonably necessary and which have been directly incurred. The Board of Governors of the Federal Reserve System shall, by regulation, establish rates and conditions. 1. Costs covered. Search and processing costs, reproduction costs, and transportation costs. 2. Fees are established by Reg S and are updated periodically. Read that section. Lastly, enforcement. This is the last ever. Civil liability, $100 per occurrence. Actual damages, punitive damage for willful or intentional violations. 4. Court costs and reasonable attorney's fees. Then there are fewer penalties, up to $7,500 per day for violations of laws and regulations. 2. Penalties up to $37,500 per day, violations or unsafe or unsound practices are engaged in recklessly or are part of a pattern of misconduct that causes more than a minimal loss to the bank or any pecuniary gain to the parties involved. 3. Penalties up to $3.175 per day against persons who knowingly commit a violation and knowingly or recklessly cause a substantial